Started. Thank you for joining us on our April 2018 banking webinar for Gisleson and Hunter. As I indicated, my name is Dan Beckman. I'm a partner in our Minneapolis office. I'm going to start with the subject of landlord consents. Mike Dove will then cover the second and third topics, which are lending to trusts and ag liens. You do have the ability to ask questions online through the chat function on the webinar feature. We do these online seminars a couple of times a year in addition to our ag lending seminar, which is in New Ulm in September, and our Minneapolis banking seminar, which we typically hold in the Twin Cities area in the fall. If you have ideas for other webinars or would like us to come up to your financial institution on a particular topic or presentation, please let us know. We welcome all suggestions. Starting this afternoon, the slides and the recording of this webinar will be available on our website. With that, we're going to get started on landlord consents. Full disclosure to all of those attending here today, I do represent commercial landlords as well as banks and financial institutions. So some of the comments that I will give you will be from the perspective of my commercial landlords as well as my banking clients. A landlord consent is a document which deals with the relationship between a lender and a landlord when the loan is secured by personal property located at the borrower's place of business, which is a rented location. So this landlord consents deals with the situation where there is a third-party owner of the property that may have claims to some of your collateral. And these claims now arise from two primary areas. They rise from the priority of competing liens and under Minnesota fixture law. Why? Because the reason why the lender is concerned about these issues is you want to have access to the property to remove your collateral in the case of a default. You may want to have access to the property for sale efficiencies to keep the property stored there while you can arrange to have an online auction or other disposition of the property. And in the situation where there's a default, you do not want to add additional cost by having to pay the owner of the property, which could consist of curing past rent or other lease defaults. So, where do these arise? The issue comes up because the priority of a security interest in personal property versus the liens that a landlord may have can be unclear under certain circumstances under Minnesota law. And these arise when the landlords have possessory liens under certain statutes as well as possessory liens because of the terms of their lease. So where do these types of landlord liens arise? First, they can arise through language in the lease document itself. A number of commercial landlords will have language typically in the latter parts of the lease which grants a security interest to the landlord. The situation can also arise under Minnesota Statutes 504B.271, which deals with the rights of a landlord and the obligations of a commercial landlord to deal with property left behind by the tenant. That statute provides that a landlord may sell or otherwise dispose of property 28 days after the tenant has abandoned the premises. And the landlord is allowed to apply a reasonable amount of the proceeds to the removal, if they have to remove it off-site into a bonded storage warehouse, or for the care and storage costs and expenses, including the offset of the security deposit. So where this comes up with respect to a lot of my commercial landlords is if the tenant defaults, there's an eviction, and the landlord then ends up with this property left behind. Typically, my advice to my clients has been that the storage cost is the value of the rent, which typically is a lot higher than it would be to store it in a warehouse or somewhere else, and those storage costs can increase rapidly. And so depending upon what type of collateral you have, it may very quickly diminish the value of repossessing and liquidating that collateral. The issue also arises with respect to Minnesota fixture law because it can be very factually based under Minnesota law as to what can become a fixture and ultimately then determined to be a part of the property owned by the landlord versus what remains personal property and is able to be removed by the tenant upon the termination or expiration of the lease. Minnesota courts will consider a number of factors which we set forth here on this slide. The primary one is whether or not the property was attached to the realty with a sufficient degree of permanence that the attachment alone changes the character of the property from personal property to real property. Things that I've run across in my practice are dust collection systems, generators, air handling systems, restaurant exhaust hoods, things like this which can be partially attached to the real estate and incorporated into the commercial property have the tendency to be considered fixtures. The landlord is going to suggest that those things can stay after the fact if they believe that there's some value to their property in having the property remain behind. Other factors the court will consider: the intent of the parties, the nature of the property itself, the adaptability to the use of the land, and the end sought by annexation. So what this means is if something's incorporated into the property and removing it will essentially render a significant part of other improvements to the property useless, such as air handling systems or a restaurant exhaust hood, things like that, that would tend to lead to the conclusion that it was more likely a fixture than remaining personal property of the tenant. And how it is annexed also has a factor in determining whether or not it's going to be a fixture and owned by the landlord. In my experience, landlords typically do not want the personal property left behind, as it is often more expensive for them to remove and dispose of the property than there is any value to the landlord. So the best thing, if we would go back, whether or not this is a fixture, is the intent of the parties. So if you enter into a landlord consent with the landlord and your borrower, where all parties agree what is or will not be personal property and subject to the landlord's security interest, that's the easiest way to take care of this situation, and why we recommend for all parties involved that landlord consents be prepared and executed. The landlord will have a number of concerns in any proposed landlord consent that's presented to them. Number one, they're going to want some kind of indemnification from the lender in removing the property. If they're going to allow third parties onto their property, they're going to be removing items, potentially taking things off that could be fixed in some way. They're going to want indemnification for any damage, injury claims, as well as some sort of indemnification for any other damage that occurs to the property. The landlord's also going to be concerned with the condition of the property upon removal. I've had commercial landlords complain and seek from the lender costs of the damage to the removal of the property. Typically, leases have a requirement of the tenant to, broom clean the property, and so the landlord doesn't incur costs from the removal of the property. The landlord's going to seek some sort of assurance that if the lender comes in, that they don't just take what they need, live behind a bunch of junk and dirt and other things. So they're going to want some representation that the lender is going to come in and do things in a proper manner. The issue of timing also is typically addressed in a landlord consent. The lender wants sufficient time to remove the equipment or to evaluate any kind of disposal options. Typically what this means is that the lender is going to want the option either to come in on a short-term basis to remove it or to lease the premises while they either store the property there or have an opportunity to remove it. The landlord, on the other hand, is going to want to be compensated for the time the lender controls the space. And one of the big issues that I regularly see is whether or not the lender is obligated to pay rent on a daily or monthly basis. So when I'm representing landlords, we always seek a rent on a monthly basis. When I represent banks, we try to get it down either that you have the opportunity to take it out without paying any rental obligations within a certain period of time, or you agree to pay it for just the time that you're in the space. Quite frankly, from the landlord's perspective, if they're delaying their efforts at getting the space cleared up and potentially available for a new tenant to come in, it's reasonable for them typically to suggest that they want a month-to-month kind of rental situation. The lender, on the other hand, is going to say, we can tell you when the property is going to be removed, when we're going to have our online auction, so you can go out and market the space. You'll be able to understand what date will be out, and so you can get your contractors in to do any improvements for your new tenant. Typically, the lender in the landlord consent is going to want notice of any default by the tenant. Most commercial property that's professionally managed or has an owner that is savvy to managing commercial property is going to agree to provide the landlord notice. Again, number one primary reason is that the landlord does not have an interest typically in having to dispose of the property, and so they're going to want the lender to be aware of it in the hopes that the lender will come and take the property out of the space. There will then be a trigger of the right of occupancy by the lender or a right to cure any default of the borrower in the rent. The landlord consent, as I mentioned earlier, should include a definition of what the secured property is. The more specific you can be, the better, because that will eliminate any sort of dispute in the future. If you have an itemization of what property is secured by your security agreement, I typically recommend that you attach that to the landlord consent as an exhibit. I do want to point out that most landlord consents will make a distinction between an assumption of the lease obligations versus occupancy of the property and an obligation to pay rent. And what I mean by that is that the lender, in coming in and agreeing to pay some amount to occupy the property or to remove their collateral, does not agree to assume any other lease obligations or prior defaults, but rather has the right to come in and occupy on a temporary basis simply to deal with the personal property and remove the collateral. So we do have, I know there are standard forms in a lot of the bank loan document software programs. I have a typical form that I use on behalf of my commercial landlords, and if anyone has any questions about these issues, we'd be happy to discuss them at some point in time in the future. Just give me a call. And with that, I'm going to turn it over to Mike.
Thank you, Dan. Dean Zimmerly wasn't able to be with us, so I am covering and pinch hitting for him. And one of the things that we've seen recently in our practice is that a lot of estate planning is being done and they are forming trusts. And there can be a number of different trusts that can be formed through that estate planning process, and the lender needs to know and be aware of which trusts are out there and who owns the property and what is going to happen with that. As I tell every lender, one of the most important things to do, in my opinion, is ask every year if there's been a transfer of any real property or personal property into a trust, or for that matter, into any other corporate entity, so the actual owner of the collateral, potential collateral, is properly identified in the lender's loan documents. So when you lend to a trust, there's a few basic things that we need to be aware of. First, the trust is a relationship between the grantor, the one who makes a grant of the property, to be held by the trustee for the benefit of the beneficiaries. For purposes of today, there are two broad categories of trusts, and I'm sure we've heard this, but just to review, the revocable trust and the irrevocable trust, and we will discuss each one of those in a little detail as far as the nuances and what needs to be done on that part of it. We should also focus on, one, who is borrowing the money, and two, who owns the security for the loan. If for example, if there's real estate held in a trust, yet that trust doesn't have any earning capacity except for the potential rentals generated from that, but the borrower is going to be an individual, it's going to require a process to make sure that we have the right borrower for the personal liability and the right grantor for the security for the loan. A couple general rules for signing loan documents. The trust signature must include the name of the trustee, not just the name of the trust. And this is true whether it's in real estate or the security agreement, or the promissory note, whatever loan document you're going to use that is required for that process. So the wrong way, as we have here on the example, is the Huey, Dewey, and Louie Trust. The correct way is to identify the trustee, identify that person as the trustee of the trust under the agreement dated, and in this case it was 2/1/2014. It's also important for lenders, once we identify the creation or existence of the trust, to review the trust documents to ensure the correct persons are identified. Often the settlers, the trustees, and the beneficiaries get confused about their legal status, and that can cause confusion as to what powers each of those individuals has in their respective capacity with the trust. So there's three basic trust documents that we need to review. The first one is the trust instrument itself, and this is the document that creates and governs the trust. For testamentary trust, those are the trusts that are part of a deceased will. Another example is that, one document can create various trusts, whether it's as our example, a revocable trust with a marital trust and then a family trust. So as we go down this process and we find out this information, we're going to actually end up, kind of creating a spreadsheet or, flow sheet to see who owns what and what powers the trustees have and who the settlers and the beneficiaries are, as that will make a significant difference in how we approach lending to a trust or obtaining collateral from a trust. The second trust document is a certificate of trust, and this is a recorded document summarizing the trust terms. So basically, instead of reading an 87-page trust, you might read a 10-page summary of the trust instrument, and this is done so the whole document, the trust, does not need to be recorded. The certificate of trust should show the trust's existence, when it was established, what powers the trustee has, and identify the trustees. It will also identify sometimes if there is a co-trustee. Do you need to have both co-trustees sign the documents, or just one individual trustee sufficient? The certificate of trust is important for that, to give you guidance as to who should be executing the loan documents. If one certificate of trust is on record and nothing has changed since it was recorded and there's no other updates, for lack of a better word, you do not need to have the trustee execute a new certificate of trust. That is established once the trust is there. If there's been a change of trustees, then a new certificate of trust should be established and prepared. And again, that's just some of the due diligence that you as lenders will need to do when you're looking at this process. The last document is the affidavit of the trustee, and this is a recorded document affirming the trustee's authority to sign and enter into these, into the loan documents. It affirms the identity of the trustee and that the powers I will, as trustee, I can grant a mortgage on this real estate is within my power. We do recommend that you execute a new affidavit of trustee every time you enter into a loan transaction. And again, that's just to show and have them make that affirmation that they have the power and the ability to do that. Special issues when the borrower is a revocable trust. We've all heard of revocable trusts. Basically, the grantor of the trust retains the power to revoke it or undo it at any time. Now, this can create problems when you're a lender because you think you're going to, make this loan and have the, you've done all the proper things and you're going to make it to the trust. Now, the lender all of a sudden says, forget it, I'm going to revoke the trust. Now, what are we going to do? Well, again, it's going to be important for the lender to take a couple of steps, in my opinion, to facilitate and make that potential and very easy transaction to revoke a trust with the borrower. So what we recommend doing if it's a revocable trust is to, for the credit agreement and the security agreements in the UCC, have both the trustee and the individual grantor execute both of those. One in the capacity of the trust, so it would be, as we said in our slide before, it would be, Mike Dove as trustee for the trust and then Mike Dove individually. Another word of caution here is sometimes married couples have each set up their own separate trust. So the trust, some real estate can be owned by two different co-trustees along that line. Again, the due diligence in researching this will establish what needs to be done. But the long and the short is with a revocable trust, because of the ease to undo it, we recommend that both the individual signs as an individual and as the trustee of the trust. That way, if they revoke it, you're still covered on that process. For the mortgage, whoever is the title holder of record, and exactly as is stated in that vesting instrument. That's just, again, good lending skills from that part. And our last bullet here, as we all know, when we make loans to individuals or or to trusts, they don't always remember to tell you when something changes, and that goes back to one of my beginning comments where it's always important to ask the borrower at the beginning of any loan relationship if anything has changed with them with respect to their operation insofar as entities or the establishment of trusts. So now we have the revocable trust, which is the other type of trust that we do. And the irrevocable trust, I should say, is truly that, irrevocable. They cannot go back and undo it. And that's why I'd say in my practice, 80% of the trusts I see are revocable. But anyway, with the irrevocable trust, we can have the trustee of the trust sign both the credit agreement and the security agreement, or UCC. Again, for the mortgage, whoever is the title holder of record, it should be executed exactly as stated in that vesting instrument. Under the irrevocable trust, the grantee usually has no or certainly very limited powers, yet the trustee is the decision maker for that process. Just one other item of note is that just because the word revocable is in the trust name, it doesn't necessarily mean it's still revocable. The trust instrument itself will state when the trust can be revoked, and in a revocable trust, that usually means until the grantor's death. So what are some of the issues we have when we're taking collateral with an irrevocable trust? Most trusts give trustees very broad discretion in the management of the trust assets, including the power to pledge assets as security. But the power within that is not necessarily automatic, so we still need to review that trust document. Also, the trustee powers can be limited by a trustee's fiduciary duty to the beneficiaries. So the difference between the irrevocable trust is the grantor still has full and complete control, and while there may be beneficiaries in that trust, as long as the grantor trustee retain that control, they can pretty much do whatever they want. However, when we get to the irrevocable trust, we need to make sure that the actions taken by the trustee with his fiduciary duty to the beneficiaries, and again, it's different here because we can't undo it and give it back to the original grantor, must act within those powers, and the trustee's best interest is for the beneficiaries versus the individuals. And in certain instances, beneficiaries can come back and undo those acts of an irrevocable trust because the trustee was acting outside the scope or was acting without the beneficiary's best interest. So, for example, if the trustee, as a hypothetical, was going to, pledge some of the land to secure his own personal debt, one would have to question what is the real purpose of the trust, the irrevocable trust, pledging land to secure the individual trustee's obligations. So again, as we go through these processes in making loans to trusts, we need to be mindful of that difference between the revocable and the irrevocable trust, and specifically the actions of the trustee in an irrevocable trust situation. Our recommendation is if it's an irrevocable trust and when you're in doubt or the stakes are high, I mean, if it's $50,000, it's $50,000. It's a $5 million loan, much higher stakes. To avoid the potential problems is by getting the beneficiary's written acknowledgement and consent to the guarantees or the pledges of the collateral by the trustee. Again, you may say, well, how are we going to get that information? All that information will be contained within the trust document itself as to who the beneficiaries are. Now, there's certain situations where all the beneficiaries aren't old enough or mature enough to sign the documents, and the Minnesota Trust Code has clear rules regarding virtual representation of those beneficiaries, basically saying who can sign on certain beneficiaries' behalf. We could probably do a full seminar just along the irrevocable and the beneficiaries process, but this is just an overview. And again, if you ever get in the situation, please feel free to reach out to Dan or myself, and we can guide you through this process. The goal here today is to just make you aware of and that there are certain risks and things that you need to be aware of when you are making loans to trust, both the revocable and the irrevocable trust process. So that's kind of where the end of the trust documents. Dan, do you have anything to add on this?
No, I don't, other than the irrevocable trust comments I think are well taken because they do arise, and a couple of points to emphasize I think that Mike touched on. Number one, you can have a revocable trust that can become irrevocable. So even if you're given a copy of a revocable trust, you need to make sure that under the terms of the trust is in fact still revocable. And number two, when you're dealing with an irrevocable trust, really look at the intent of the loan that you're making to make sure that there is a specific benefit conveyed on the beneficiaries or for the purposes of the trust to make sure that the trustees' rights to sign off on that and provide the promises to the bank are in fact appropriate.
Thanks, Dan. So again, that's just something to be aware of, and before, especially like I said, in that irrevocable manner, might be good to reach out for some legal guidance. The next thing we're going to talk about in Section 3 is statutory agricultural liens. When we were putting this seminar or webinar together, we were thinking, shoot, you know, we're kind of getting right in the middle of planting season. Well, thanks to Mother Nature, we haven't had planting season, so yet at this point. So this is a good precursor for what some statutory liens could be here in the next 30 to 60 days. The first, I'm going to be talking about 6 different types of input liens, for lack of a better word. Minnesota statutes provide various statutory liens to provide protection or attempt to provide protection to those who contribute to goods or services for the benefit of an agricultural farming operation. That includes crop production input liens, harvesters liens, landlords liens, livestock production input lien, which is basically a mirror of the crop production input lien, except it has to deal with livestock inputs, the feeders lien, and last but not least, the veterinarian's lien. So, given that we are going to be in the input season and that the agricultural economy is tight, to say the least, you know, there's certain individuals, borrowers of yours that are probably out there. Some probably have not had their financing lined up. The lender is not going to renew them. They've told them this process. And then that borrower may find someone who's going to provide them, for example, a cooperative or something like that, is going to provide them inputs on that process. And this is where the crop production input lien comes in. As you can see, it's codified, or it's identified at Minnesota Statute 514.964, but basically it's a supplier furnishing crop production inputs in the ordinary course of a business that has an agricultural lien for the unpaid retail cost of the crop production inputs. So it's not a new borrower out there, or a new lender, I should say, out there who's going to provide financing to Mike Duff for his crop farming operation. It's a supplier furnishing crop production inputs who has this ability. What is a crop production input? Under the statute, it includes ag chemicals, seeds, petroleum, custom application, and labor used in preparing the land for planting, cultivating, so on and so forth. So it would be your standard crop, crop inputs. And specifically, ag chemicals includes fertilizers or ag chemicals that are applied to crops or to land used for raising crops, and it includes pesticides. So if you have somebody coming out and doing Roundup application for Roundup Ready soybeans for that required, or for pesticides for corn borer, something along those lines, that's all going to be covered. Where this can be unique with respect to inputs is that the 2017 crop or 2018 crop can be encumbered by fertilizer applied last fall. So it's something to be aware of. You may, they have not had yet or required yet to send out that notice, as we'll find out later. Also, petroleum products means, fuels basically, and also oils, which usually is very small, but fuel can certainly be a big input from that perspective. What does the crop production input lien attach to? It attaches to the existing crops upon the land where the ag chemical was furnished or supplied, or if crops are not planted, to the next production crop within 16 months following the last date of the application. So that fall fertilizer that was applied last fall, that could attach to the crops that are going to be planted here in the next couple of weeks. It also attaches to the crops produced from furnishing the seed, and the crops produced using furnished petroleum products. So basically it's the crops. It's not going to attach to machinery and equipment. It's not a blanket lien by any means, but as one would guess, the crop production input lien would attach to the crop production for which it's being used. It is possible, and this is why we're talking about this, for a crop production input lien to gain priority over a lender's existing security interest. The first thing that needs to be done is the crop production input supplier must provide the lender with the lien notification statements. If any of you have attended our Ag Lending Conference, we went over this, but I think it's very important to go over it again. That notification statement must include the name and address of the lender who's going to receive the statement, the name and address of the supplier, a description, a date, and the cost or the anticipated cost of the crop production input, and then the person or entity who is to receive the crop production inputs. So they're going to tell you everything right up front, who's putting it in, how much it's going to cost, and the person who's going to receive the benefit to give you knowledge as far as where that individual is sitting. Now, this is the part where the lender has a couple of choices to make, but also must be aware of these notices coming into your office. As the slide says, in order for this lien to gain priority over the existing interest, within 10 days of receiving the notification statement, the lender must either respond with a letter of commitment, which says, okay, we'll cover this for all or part of it, or provide a refusal to provide a letter of commitment. And the bottom part here is the most important. If you don't respond within 10 days, a perfected crop production input lien is going to have priority over any security interest in the same crops or their proceeds. And, 10 days we think is quite a bit of time to turn around, but I would encourage each lender to make sure that if you're going to be out of the office on vacation, or if you're going to be gone for a few days, that this letter, because it just needs to be sent to you, this letter does not get lost or misplaced in your file. Because if you don't respond within 10 days, it's going to have a dramatic impact on that process. Now, the one thing that you need to be aware of is that the letter has to say important legal notice on it. We talked about this at the Ag Lending Conference, that there was a case where somebody provided the input notice. The lender did not respond within 10 days, but because the words important legal notice were not included on the envelope, the Minnesota Court of Appeals held that the lender still had a priority security interest even though it didn't respond. So, again, make sure that we have some backup mechanisms to allow you to respond timely within that 10 days. I can honestly say, in the years I've been doing this, I've never seen a lender just say, yeah, go ahead and have a priority lien. So, but it's out there, and the 10 days can check you up, check you up on that part of it. Here's just, again, a brief example. Lender has a security interest in all the crops. Co-op agrees to sell seed corn, sends a notification to the bank for the $20,000 of seed corn. Bank responds by agreeing to finance the $20,000. At that point, the co-op doesn't obtain the lien because presumably they're going to get paid the $20,000. There's no need for that lien to do. Refuses to provide the $20,000. Then the co-op retains a lien right, but it's not going to jump over the lender's security interest. It's going to be subordinate to that. But if you don't respond within the 10 days, then the co-op's going to have a priority lien on the crops to the extent of the dollar amount stated in the notification. The next lien, which I think is going to be pertinent this year, is the landlord's lien. And basically, a person leasing real property has a lien for the unpaid rent on the crops produced on that real property that is the subject of the lease. And the landlord's lien becomes effective when crops become growing crops. The landlord must file a financing statement to perfect the security interest as a landlord's lien, and the landlord's lien must be perfected on or before 30 days after the crops become growing crops. Now, you may ask, what does it mean that crops become growing crops? And the answer is that's a really good question. There is very limited case law sitting out there to address that, but I think a crop becomes a growing crop, or you can make the argument the day that it's planted into the ground. So there's basically a 30-day window for this landlord to perfect. Now, as the lender, if you're lending to a landlord, let's say you have a mortgage on a piece of property that Mike Dove owns, and Mike Dove is renting it out to Dan Beckman, you might want to encourage Mike Dove to file a landlord's lien, because that landlord's lien will ensure that Mike Dove gets his payment which would be used to make his mortgage payment to the lender. So there's two different ways from a lender's perspective in monitoring and keeping track of a landlord's lien. The one issue here is that you don't have a choice. The lender doesn't have a choice or has the option to consent to the landlord's lien. The Minnesota statute is clear that if a perfected landlord's lien is filed, it does have priority over all competing security interests in all ag liens in the crops and the products and the proceeds of those. You know, I've had borrowers say, well, I'm just going to have my, just advance me the money for the rents because I'm just going to, pay it to the landlord and he's going to have a lien over it to begin with. If you do that, if you make those advances, you may want to follow up and check and verify that the landlord actually gets paid. Surprisingly enough, as we've said before, sometimes they forget to pay the landlord, or sometimes they're just not honest about the whole process. But you need to know that if the landlord files a lien, it's going to have a priority lien over the lender's lender's lien on those crops from that perspective. It is limited to the crops grown on the land rented, okay? So, and it can only be for the amount of the unpaid rent. Used to be that it was always 50-50, 50 in the spring, 50 in the fall. I've seen more of a tendency. It's probably 80% paid up front now versus splitting that, but it's it can create problems for the landlord. If the crops are commingled, it's going to go through some process. But the long and the short is the landlord files a lien, it's going to get paid and will trump the lender's security interest in that process. Moving towards fall, we also have the harvester's lien that's sitting out there. And this is a lien for providing combining, storage services, hauling, anything that you could think of basically for a harvester that can be used if they don't get paid. The harvester cannot assert a crop production input lien because it's not a crop production input lien for the same goods or services. And there's been a couple of cases where people have tried to loop in and come through the back door on various processes to try to beat the banks. And the Minnesota Court of Appeals has been pretty consistent that if there's a couple of different competing liens sitting out there, the one that's designated for that process, for example, harvesting, would be the lien that would have to be followed. Perfection, they need to file a financing statement within 15 days after the last harvesting services are provided. And again, if they have that process, the perfected harvester lien has priority over all competing liens except for the landlord's lien and a perfected crop production input lien. So again, there's not a lot of discretion for the lender to try to fight or defeat the lien if it's properly perfected for the harvester's lien. Moving on to livestock production input liens, and again, I'm not going to go through this one in quite as much detail because it basically mirrors, it has the same information and requirements as a crop production input lien. It's just for livestock. And as we see here on the slide, it's a person supplying inputs for the supplier furnishing livestock production inputs in the ordinary course of its business. What does that mean? It means feed and labor, which is something that we need to be aware of. It's not just the feed that's coming out there, but if there's a person who's putting labor into raising of the livestock, that could possibly fall under the livestock production input lien. What does livestock production lien attach to? The livestock service by the agricultural lien holder, whatever interest you have, that's what it would attach to. Again, as with the crop production input lien, it's possible for the livestock production input lien supplier to trump the blanket security interest or the lender's blanket lien. It has to go through the same process, the same notification, has to have the same information set forth on that notice that's given to you. Again, the name and address of the lender, the address of the supplier, what's going to be, the cost of putting it in, or the anticipated cost, the person who's receiving the livestock production input, and then the name of the person who owns the livestock and its location and description. As with they have 10 days to respond. Again, the same process for a livestock production input lien as a crop production input lien. The feeder's lien is relatively new, and I mean within the past 15 or 20 years. that's been done there. And a person who has a feeder's lien, if the person stores or cares for, contributes to the keeping, feeding, or the care of the livestock, including medical or surgical treatment, and does so in the ordinary course of the business at the request of the owner or legal possessor of the livestock. Again, this needs to be perfected by filing a financing statement within 60 days of the last providing of the feeding services along those lines. And in that situation, the feeder's lien is going to trump the blanket security interest. It's one of those absolute liens as a landlord's lien. There was a Minnesota Court of Appeals case probably 3 to 4 years ago, and we discussed it at the Ag Lending Conference, where a livestock production input supplier tried to assert a feeder's lien, which would have primed, the blanket lien holder by saying that, hey, we provided for the keeping and the feeding of this. The Minnesota Court of Appeals rejected that argument, saying this is for the person who is actually doing the feeding, who's actually taking care of them. So the co-op in that instance who had supplied feed was not entitled to a feeder's lien, but instead had to go back under the livestock production input lien statute. And in that case, the lender had properly rejected the input lien by providing that written notice within 10 days. And this was an attempt to circumvent the livestock production input lien statute by saying that, hey, this is a feeder's lien because the language says stores or cares for or contributes to the keeping and feeding. And again, the Minnesota Court of Appeals said, well, that was a nice try, but it didn't work for them along those lines. So that's the feeder's lien from that perspective. The last lien that I'm going to discuss here, and we're finishing a little early, which I'm sure will not disappoint anybody on the conference call, is the veterinarian's lien. And this, the licensed vet is performing emergency services on an animal, has a lien for the value of the services. Again, this is an absolute lien. It primes a blanket lien holder. This statute goes back to the 1800s when veterinarians didn't make routine calls for the health performance of a livestock producer. I mean, they truly probably only came out when there was an emergency. The Minnesota legislature has not revised the term emergency services. And I presume there's going to be a debate at some point coming down the line, or a case that veterinarians going to say, they're routines. Are they routine services or are they emergency services? And how do you classify and distinguish between the two categories of service that a veterinarian is going to perform, given in today's modern agricultural livestock production scenario? So this is one that's out there. Again, it says it's limited to emergency services on the animal for the value of the services, but there's no law to really define what emergency services means in today's context. The priority, again, the veterinarian's lien has priority over all competing security interests. The feeder's lien has priority over a security interest and the ag liens, except for the vet's liens. And there's also a perfected breeder's lien, which has priority over a blanket security interest and ag lien, except for the vet and feed lien. So basically, in the livestock production, the priority is the vet's lien is first if it's done properly. Then comes the feeder's lien. Again, no discretion or opportunity for the blanket lien holder, the lender, to say, I don't want to give you a lien on that. The feeder will get paid from those proceeds. Then the breeder's lien, and then just down to the blanket security interest, again, unless there was going to be a livestock production input lien and you failed to respond, and at that point, that perfected livestock production input lien is going to be senior to the just blanket lien holder. Dan, any comments on this? I went through a whole lot of stuff in a relatively quick time, but I wanted to give an overview for some of the things that we may be seeing, given that today is April 25th, I believe, and we're going to be planting and going hard here in the next 3-4 weeks.
Mike, my question to you is, given the priority of the feeders lien, is that a situation that could be similar to the landlord consent that I talked about earlier, where if you're aware your borrower is going to be having livestock on rented property and somebody else is going to be carrying, that you can have a subordination type agreement put in place to trump what the statutory priorities are?
Yeah, you can. In my opinion, you could do that. I don't think there is any prohibition in the feeders lien that would say you subordinating to a blanket security holder is in violation or prohibits that type of thing. So that's a very good point, that if you're in that situation, that would be a possibility to further secure the blanket lien. So, good point. That concludes our webinar. Again, thank you very much for attending today. As Dan said in the beginning, we're always looking for topics, whether it's for our Ag Lending Conference or our Metro Banking Conference, or our financial newsletter, for webinars. And you have Dan and mine and Dean Zimmerle's email addresses on this material. Please feel free to shoot us your ideas. It's certainly much more fun to discuss ideas that we know lenders have an interest in than us trying to guess what the heck's going on out there. So we appreciate that, very much, and any, help that you can, assistance, I should say, that you can give us in identifying the issues that are facing you on a daily basis. We're more than happy to do that. And also, as Dan said, if you have a group out there and you want us to come out and talk for a couple of hours and do a presentation to identify some issues you're facing, please feel free to give us a call and contact us, and we'd be more than happy again to assist. So with that, I think we're going to sign off. Again, thank you everyone for participating, and we will hope you have a good day. Thank you.
Hey, Mike.